there, Internet. Good morning. It's Heather with Raindrop Works. We are still setting up um, on this end as well as waiting for the court to open the WebEx link. Amen. Okay, so yeah, we are still definitely waking up. At this point, the court has not opened the WebEx um, link, so I can't actually start the stream yet. But and while we're waiting, I have good news from last night. I found the cat. I'm, very tired and worn out from having to rescue her, but she has been found. She is back home, and that is one huge less thing I have to worry about. there was much rejoicing. Um, yeah, and I think everything on my end is set up, at least now, until people start showing up and there starts being conversation. After incidences that we had Friday in particular, I am significantly amping up the moderation in the stream chat. I did some videos over the weekend discussing how to, how I felt comfortable being able to address it. Finding the balance point between my comfort and desire to get information through, from other people to be able to contribute to the chat while also being mindful and respectful about people that are already in the chat from having to deal with harassment and other harm. And I know there are people that are not entirely happy with the option that I've gone with. Still not ready to connect yet, but I think we might be starting to get closer. I think the courtroom is getting set up. And yes, we had the running joke Friday about because the judges helping get bagels for the jury. I wanted a bagel, and I now have a bagel. So I'm just randomly chatting at this point because I do not know what to talk about, and I don't want to just sit here, have everybody stare at a big black box and. She is. She's apparently napping right now. She's still a little dirty. Um, Nowhere near as bad as when I found her. It turned out she actually got underneath the apartment building because of some bad maintenance work that was done. Um, there's a hole to a crawl space that she was able to get into but not out of. And I found the hole last night and we're able to get her out. As far as I can tell, I think she's going to be just fine. She's eaten. She's gotten lots of attention from me. She's been. Yeah, it was. There were definitely emotions last night. Ah, but now they are all good emotions, and um, at this point, I just need to um, my other cat, the calico, seemed to have enjoyed having time to herself, and is now a little jealous that the other one is back. So there's that, but things will get better in a few days. Yeah, I was really worried last night when I found out where she was because like there was no food, no water down there, and I'm really surprised she did as well as she did. I mean, she was able to walk around, and once I knew she was down there, she became very chatty with me and didn't want to be grabbed, which is normal. Uh, how long was she gone? I have to refresh my memory. I can't remember if she got out of the house Wednesday night or Thursday night. Um, so I sent a tweet out about it on the 30th. So yeah, so since Wednesday night she was out of the house. because I tried looking for her for a day before I started asking around for people to keep an eye out for her. So yeah, yep, 4 days she was under the house, almost 5. But yeah, I'm I know that when cats are injured, they tend to not eat or drink and just hide away until they heal. But she wasn't injured, so I'm just really surprised and really lucky that also, as you might be able to tell, I did get the chat box fixed last night. Oh, good. The WebEx is now available. So I just need a minute now to do the setup on this end. Um, Switch to headphones. Oh, I need to do one more because I couldn't make sure that. Now, keep in mind, as far as for today's schedule, we still have to, we're going to be starting off with the judge still needs to share, go over the points of law in regards to the, um, the individual charges. And then, oh, that must have shut that one down. Sorry, the individual charges, the law surrounding it. Then they'll do closing statements, and then we'll be able to then we'll be able to have them go to deliberation. I'm not sure yet how, because deliberation can take anywhere, a half hour to days. I kind of expect this will be on the short side of things, but I don't know how we will be notified when the jury has reached a decision. Um, so that's kind of one of the things where we're still up in the air about. um, um, hmm. Sure, we could do a poll. I will say that it's not going to be a unanimous because there are people that would respond to it that are going to have differing views. Give me a second here. I've got a bot on Twitch that I need to kick out.
Of the case support such a request. Last week, both parties cited State v. Wesley for their respective positions. The state for the position that the doctrine of transferred intent remains a common law doctrine applicable within the criminal code, and the defense for the position that the doctrine is limited in its use only to murder cases. Indeed, Wesley's focus was on intentional murder when analyzing the applicability of transferred intent, but one problem with the defense position is that intentional assault in the second degree is a lesser included offense of intentional murder. It simply does not follow that the doctrine could not apply to intentional assaults as well. There are not cases in Oregon that answer this question. I acknowledge that, but other jurisdictions have answered this question. Those cases tend to focus on whether the crime at issue involves a requirement to prove intent to do something to a particular victim and another person is injured. That is the precise situation we have here. Washington State has many cases, some of which the parties discussed. State v. Elmy, 138 Washington Appellate Court 306, State v. Clinton, 25 Washington Appellate 400, State v. Wilson, 113 Washington Appellate 122, and State v. Aguilar, 176 Washington Appellate 264. They all apply transferred intent to assault and not murder. And while the defense in its written motion equated the assault statute at question in Aguilar with Oregon's felony murder statute, I felt like that was kind of picking a line out of one case to make a specific point. And in any event, I think the reliance fails as the other cases make it clear that unless a statute requires that intent match a specific victim, intent may transfer. Just notably for me at least, the Elmy case spent a fair amount of time discussing how other jurisdictions handle transferred intent. And at least in the state of Washington, a person can commit a felony through the doctrine of transferred intent even if they don't know their victims are present. So in that case, a gentleman shot into a window where 4 people were in a room watching television. His intent was only to kill one of the people in the room, did not know the 3 other people were even in the room, and the court upheld the doctrine of transferred intent as to the 4 separate victims. In our case, assault in the second degree, as alleged in count 5, does not require that intent to match a specific victim, merely that a person intends to cause injury to another person by means of a dangerous weapon. I know the defense feels that I am creating new law. I don't agree with that philosophy. In fact, I feel it's quite the contrary, as transferred intent is a common law concept that literally goes back centuries, and its application to intentional crimes beyond murder is also well established across the country. So I will give the transferred intent instruction as it is currently drafted in the jury instructions. Mr. Westover, is the defense going to rely on its written motion for the purposes of the record, or is there more you'd like to say on this for the record?
No, I think we've got everything we need in the written motion. I'll note for the record that it wasn't the state that did additional research, it was the court. You may have misspoken earlier.
Oh, okay. Well, the court did. I thought I said the state and you sent in motions and I did additional research, but to the extent that that was unclear, that's what I meant. So thank you for that. All right. So jury instructions. I've added the use definition. I've removed self-defense from counts 6, 11, 12. I've made sure that the other counts all read self-defense or defense of others. Anything else? Typos, copy and paste errors. I did add a definition of accompanied in the self-defense stuff for the mere words and words alone if unaccompanied, per the defense request last week. Oh, and then the other thing that I did do, instead of having, so I do want to, frankly, get party preferences here. How to consider the evidence. As you recall or may recall, the state simply put in the exhibit numbers that they could consider as to both incidents. I instead changed it to kind of let the jury use their common sense by saying,
I think we need to specifically limit it to what, because, I mean, I do think we also need, well, I'm not sure we do, but I do think we need to limit it to the exhibits that apply to all. I mean.
okay, so you preferred the state's version.
I don't have that in front of me, but to the extent that the exhibits that can apply to all are specifically identified, I think that's more helpful to the jury.
Okay.
Than just saying it's obvious.
All right.
Could you perhaps just keep the court's language and then add in the states at the bottom? Is that, without seeing it written out, it's a little hard for me to know, but.
So yeah, I could say you may consider them for that purpose as to either incident. Specifically, those exhibits are, now, I think we've added some to this list since the states.
Well, have we though? I mean, one, the additional, what you allowed additionally after we opened the door was for impeachment by collateral evidence. It wasn't coming in for intent, motive, etc.
Okay, we'll just leave it at 5, 6, 7, 90, 91, 100, 101, and 102.
And I would request, I guess, an instruction on impeachment by collateral evidence to give the jury an idea of what exactly that stuff can be used for.
Okay, so you need to give me language and we need to discuss the specific language and then I will decide whether or not to give it. But we had a weekend to do this. It's now 5 to 9. So what would you like it to say?
Exhibits X, Y, or Z. X, Y, I think you got 2 or 3 more in. May not be used for any other purpose than towards your evaluation of the defendant's credibility on the stand. You may give whatever weight you deem appropriate for that purpose and that purpose alone.
I'm okay with it except for the last part because it actually came in substantively as well. So, I mean, that's part of the problem is that Mr. Westover skipped over that part. And that's the kind of the problem with this whole discussion is that the court's ultimate ruling was that it comes in substantively as well. So.
I do feel like that's where we landed at the end of it all. So, exhibits, what were the exhibits that came in for impeachment? One.
In that case, if the court's ruling is those come in for substantive, that Mr. Swinney is in fact the tip of the spear, then I'm withdrawing a request for instruction.
Okay, well, we differ as to our interpretation of what that evidence said, but that's fine. It's not fine. Okay. So now that reads, as you review the exhibits in this case, some are obviously related to one specific incident. Those exhibits are evidence and must be limited in their use as I've outlined above. Other exhibits more generally address plans or motive for both dates, and you may consider them for that purpose as to either incident. Specifically, those exhibits are 5, 6, 7, 90, 91, 100, 101, and 102.
We would probably want to add defense 204, I think, the last parlor post that we got in.
Okay.
I'm sorry, I want to understand where we're at in the jury instructions with that, adding that one.
That it can be used as to both incidents.
It was, I believe, postdated to the second one. I'm sorry, it was postdated to the first one incident.
No date on it.
I don't have it in front of me, so.
The point
The
is,
one
it
about
shows- the point
loaded
is-
guns and unloaded guns and all that, right?
Sure, and the point is, it shows it shows an intent to follow the law
It's fine here. Just
and a plan to follow the law.
Right. Okay.
I have one comment that I noticed. I don't know if it's in, I have the notes in the one that I printed up
Okay.
this morning,
Mhm.
but it looks like on count 3, attempted assault in the 3rd degree.
Second degree.
Yes, I'm sorry, attempted assault in the 2nd degree, count 3. There's a paragraph in between a person acts intentionally and a definition of dangerous weapon, where there's a definition of a knowing mental state, and there's no, I think that one might be a lingering mistake from me, but with an attempt, there's not gonna be any knowing.
There's no objection to removing that from count.
Okay, so
And then we would
take a step back. The reason that it says that is sub 4 says Alan Swinney intended to use or knowingly use the paintball gun as a dangerous weapon.
And we would also ask that you remove or knowingly used from subsection 4.
So Alan Swinney intended to use the paintball gun as a dangerous weapon and then take out the, I mean, that probably is cleaner.
That's fine here.
Okay, intended to use the paintball gun as a dangerous weapon, and he was not acting in self-defense or defense of others, and then we'll take out a person acts knowingly, blah, blah, blah. Okay. Anything else?
Here's my notes.
Nothing further from the state.
I didn't notice anything else.
All right, now let's just look at formatting and make sure that makes some modicum of sense. I am going to employ the Judge Ryan practice of giving each juror a copy while I read them. Yes?
That's
unless-
perfect. That's what I would like
Okay.
you to do.
I'm so happy that I'm doing something you want me to do. Okay. All right. Printing.
Thank you.
Oh, actually, don't mention
Is this a good time for us to step out and let council have their time with Mr.
that.
Swinney?
Let's just quickly review the verdict form, then yes.
Okay.
Oh, crap. I don't know where that just printed. I just remember. That printed in my courtroom.
While you're doing that, I guess I'll put my objections to giving certain jury instructions on
Okay,
record.
that's fine. Can I just forward it to you?
Yeah.
Okay.
With regard to the limiting instruction that I recently proposed and then asked to remove, the reason I'm asking that that be removed, the reason that I'm not asking for it is because I do believe that it's error to include those exhibits, number one, at all, and number two, for anything other than impeachment. The fact that the court has ruled that they are coming in substantively leads me to tactically not ask for that instruction.
We object to any form of the initial aggressor instruction with relation to the self as it is in the self-defense and defense of others. We object to the all of the initial aggressor. We object to mutual combat. To the extent that the court is giving a instruction on mutual initial aggressor, I don't think that accompanied, the definition of accompanied is sufficient. I've previously put on the record that I do think we need to specifically articulate which instructions we're talking about. We are objecting, I'll get there. And we're objecting to transferred intent, as we do not believe that that's an accurate statement of the law with regard to the count of assault in the second degree.
All right, thank you. On the verdict form, I've made the following changes. Count 1 now says August 15th in the descriptor, August 15th, 2020, individual in dark t-shirt on 4th Avenue. Count 3 now says in its descriptor, August 15th, 2020, male in gray shirt on 4th Avenue. Any other?
Just one last thing on that last piece. Could it be a gray sleeveless shirt?
Sure. Male in gray sleeveless shirt on 4th Avenue.
With regard to count 5, state's now proceeding on 2 theories.
I thought that's what the state was proceeding on, but I don't know.
Count 5.
Count 5, the transferred intent. Do you want the jury only to decide if it was only transferred intent, or you want them to decide if it was that he intentionally
We want
was shooting at Mr. Britton?
both theories.
Okay, that's what I thought.
We'll object to that.
Okay. Understanding that you're not waiving your objection to that, is the way it's written up all right with you?
Yes.
Okay.
Further, I don't understand the 2 different theories listed in, I guess, the jury. I'm looking back at the jury instruction now. Unlawful use of a weapon with a firearm, subsection 2, possessed with intent to use unlawfully.
What count are you looking at?
Count 8. Sorry. What's the difference between? Oh, I get it. Never mind. I'm good.
Okay,
Yeah, I was misreading it.
fine.
Okay.
So we're good on the verdict form.
Yep.
Okay, I'll have Mr. Keenan print that out, and then I'll go make copies.
Just print them all for Swedish.
No, I can just run back there. It's faster to make copies, I think.
Okay.
I have no idea what I just did. Word. I think will you print 2 copies of that? So I'll attach a copy of the verdict form to the instructions as well, but I'm gonna write copy in the presiding juror line for the copies.
One other thing, can we take DA number off of both the jury instructions and the verdict form?
Yes. All right. Hold on. Don't print the one I just sent you.
Okay.
I'm sending you a new one. And I'm sending you a new jury instruction.
Just an older adult copy of yours. Yeah, it must be. I'll just go check it. I'm gonna throw away all this stuff here just to make.
Well, I just
And
did.
our table. Talk about that. Yeah. My Gotcha.
And 4/2021. Oh, you're smart.
No, since it's double sided, I'll have it. Here,
Nathan, are you using your PowerPoint for your closing?
My rebuttal?
Oh, you're doing the rebuttal?
Yeah.
All right, I'm gonna go make copies.
Joe, can you print me up a copy of the exhibits, admitted exhibits and
Sure.
witnesses again? I left mine at the office.
Thank you.
All right, we're gonna step out.
Okay, so yeah, at this point, they're setting up some time for the defense to be able to talk with their client without anybody listening in. So we've got muted audio for the time being. I've seen Jade nitpick. Not wrong. Not so much came back, but I did find her last night. Um, what ended up happening, I was going over footage from last week, making clips to put up on the channel, and yeah, I was having problems with Facebook at all. So yeah, I think we might be missing our Facebook contingent today. But yeah, so I saw one of the shots from Wednesday's live stream with me holding her, and it hit me that, at the time, it's like, this may well have been the last time I will have ever held that cat, and it put something in me that I needed to go do another walk around the property, see if I could find her. Found out that there was we've got a crawl space under the building I live in, and one of the ventilation holes, when they did some work on the building, they didn't replace the wire mesh to keep animals out. Took a closer look, found some of her fur snagged on the hole. So we got underneath there and found her, snagged her, and got her out and inside. But yes, as far as with the case, trying to speak from a purely neutral position, I think his only remaining defense is going to be self-defense, and without knowing anything about the views of the jury on self-defense, I don't think it's going very well. Not only is she alive, but aside from her, she didn't have food or water down there, and aside from her being really hungry, she ate a lot of food. Understandably, it seems like she is perfectly fine. She's napping on the foot of my bed right now, or I'd be showing her to you all. Um, I'm sure she'll be awake a little bit later to come and get some attention. I know. Jade knows the history that I have with this cat. I, 7 years or so ago, I was living downtown in Martha, Washington, up on the fourth floor. The building has no screens in their windows and no air conditioning or anything like that. Their claim about no screens is because people would cut them for pipes, and uh, I am so sorry to hear that, Melissa. Yeah, I had um she was in a playful mood, was running across my bed, and accidentally fell out the um yeah. Okay. And the new moderation policies are, let's see. Okay. Sorry, I got distracted. Yeah, I live right next to one of the major roads, so I mean when she first went missing, that was definitely a concern of mine. Um, but I I was also trying to, I checked to see if I could see any sign that she had crossed the road and didn't see anything. I also know she is so scared when she's outside. Even in the middle of the night, I expected there was too much traffic on the main road that for her to try to cross it. So I felt safe that she was at least in my part of the neighborhood. Yeah, I'm really glad too, and I'm so sorry to hear that happened to you, Melissa. And I whatever you do next in regards, I mean, if you look at adopting another, or if you can't, I hope you're able to find peace from it. It's twice I've almost lost Yuki, and the first time it damn near broke me. The second time was still hard, and that's not something I would wish on anyone. Oh, I just got reminded of a similar situation that happened when I was a kid. I'm not gonna go over it because the channel doesn't need to be living that memory with me. I will say, I mean, looking at the chat, we go where we want, yes, but that's not a license to assault people. And that's what this trial is about. Hey there, cat. Look, I don't expect to see any docket information on this case being added today, but something could have been done over the weekend. Wannabe colonizer. I never would have attributed that to him, but okay, we are. Again, as I stated over the weekend, in one of the other videos that I put up, I am doing more significant moderation. Today, there is a link in the video description where people can DM questions to me that I can look if I want to respond to, but I am definitely going to be making adjustments to how the chat is being handled today. As far as Swinney have a record, the only record that I know about is a DUI in Texas that was a number of years ago. I don't know that I know when that was. It gets worse, Jade. This courthouse has only been open for like 6 months. It just opened up in the middle of the racial justice protests. I do remember hearing there was water damage from a sprinkler system messing up. I have not heard anything about a stalking charge. I know that Dixie Bailey, whose husband, Chris Bailey, was a witness for the defense. She has a stalking order for tangentially related acts in Clackamas County. I sat in on that hearing, and she is currently appealing that stalking order, but I don't feel like she has much of a case on that. I've wanted to, I'll just go ahead and comment it here because I've been thinking about it. when they had been off the record in that stalking case, I remember that the petitioner's lawyer had offered a deal where they basically accepted the stalking order, and if there were no violations for a year, then they would drop. They didn't take the deal. Now it's been a year later. The stalking order still stands because the appeal is still ongoing. So, I mean, sometimes there are worthwhile reasons to settle on a case. Who the heck is this? For trying to help people that were running away from the fires. There was an article that Maxine Borstein, I think is the name, with the Oregonian did, where looking at the potential sentences for some of these charges. I think the higher assault charges. That is weird. Something tells me my filters aren't set right. I didn't get a chance to work on that over the weekend. But yeah, Max with the Oregonian had looked over some of the cases, and the higher assault charges appear to have 5-year minimums. Now, a judge could say that they get served consecutively, so if he got convicted on both, it may still only be 5 years instead of having to do 5 and then 5. Yeah, and the people being held at gunpoint because they heard BLM while not recognizing that it was a reference to Bureau of Land Management, when so many of them live near BLM lands. That was painful for me to hear last year. Yeah, I don't know. I mean, looks like we are getting ready to start. So I'm going to go ahead and mute.
Hands of the jury instructions now. And you can feel free to set them aside or read along as I read them to you. We will then proceed with the closing arguments in this case. It is your sole responsibility to make all the decisions about the facts in this case. You must evaluate the evidence to determine how reliable or how believable that evidence is. When you make your decision about the facts, you must then apply the legal rules to those facts and reach your verdict. Remember, however, that your power to reach a verdict is not arbitrary. When I tell you what the law is on a particular subject or tell you how to evaluate certain evidence, you must follow these instructions. Do not allow anything I have said or done during the course of this trial to suggest that I have formed any opinion about this case. Keep in mind that a judge is required by law to give certain instructions in every criminal case. When I have sustained objections to evidence or ordered that evidence be stricken or excluded from your consideration, you must follow these rulings. Do not consider such matters during your deliberations. Base your verdict on the evidence and these instructions. The lawyer's statements and arguments are not evidence. If your recollection of the evidence is different from the lawyer's recollection, you must rely on your own memory. In deciding this case, you are to consider all the evidence you find worthy of belief. It is your duty to weigh the evidence calmly and dispassionately and to decide this case on its merits. Do not decide this case on guesswork, conjecture, or speculation. You should make every effort to be aware of your biases, including unconscious biases and what effect those may have on your decision making. In your deliberations, you must not be biased in favor of or against any party, witness, or lawyer because of the person's disability, gender, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or political affiliation. We all have feelings, assumptions, perceptions, fears, and stereotypes about others. Some biases we are aware of, and others we may not be fully aware of. These hidden thoughts can affect what we see and hear, how we remember what we see and hear, how we interact with others, and how we make important decisions. Do not allow any personal feelings, sympathy, prejudice, or bias, whether conscious or unconscious, to influence your decision making. Do not consider what sentence the court might impose if you find the defendant guilty. Generally, the testimony of any witness whom you believe is sufficient to prove any fact in dispute. You are not simply to count the witnesses, but you are to weigh the evidence. Keep in mind that each party is entitled to the considered decision of each juror. Therefore, you should not give undue weight to another juror's notes or memory if they conflict with your recollection of the evidence. The court has provided the written instructions for your use. When you use these instructions, do not place undue emphasis on any particular instruction, but rather view the instructions as a whole. The term witness includes every person who has testified under oath in this case. Every witness has taken an oath to tell the truth. In evaluating each witness's testimony, however, you may consider such things as the manner in which the witness testifies, the nature or quality of the witness's testimony, evidence that contradicts the testimony of the witness, and evidence concerning the bias, motives, or interest of the witness. Sometimes a witness may give incorrect or even inconsistent testimony. This does not necessarily constitute lying on the part of the witness. The witness's testimony may be an honest mistake or confusion. The witness may simply forget matters, or his or her memory of an event may contain honest inconsistencies or contradictions. Also, different witnesses may observe or recount the same event differently. However, if you find that a witness has intentionally lied in part of his or her testimony, you may, but are not required to, distrust other portions of that witness's testimony. As jurors, you have the sole responsibility to determine which testimony or portions of testimony you will or will not rely on in reaching your verdict. When a witness testifies about statements made by the defendant, you should consider such testimony with caution. In reviewing such testimony, you should consider, among other things, the following. Did the defendant make the statement, and if so, did he clearly express what he intended to say? Did the witness correctly hear and understand what the defendant said? Did the witness correctly remember and relate what the defendant said? Did the witness intentionally or mistakenly alter some of the defendant's words, thereby changing the meaning of what was actually said? If, after weighing such factors, you conclude that the defendant said what he intended to say and that the witness to the statement correctly understood, remembered, and related to you what the defendant said, then you are authorized to consider such statements for what you deem them to be worth. Although a witness may be allowed to state his or her opinion, you are not required to accept that opinion. To determine what value, if any, you will give to a witness's opinion, you should consider such things as the witness's opportunity and ability to form the opinion, the witness's believability, and how the witness reached the opinion. During the trial, the court may have received evidence in a modified form. This evidence may have been edited because it contained irrelevant or otherwise inadmissible material. If you notice or suspect that evidence has been modified, you are not to speculate about the substance of what may have been removed or modified or why it was modified. You should not consider evidence to be of greater or lesser evidentiary value based solely on the fact that it has been modified. In deciding this case, you may draw inferences and reach conclusions from the evidence if your inferences and conclusions are reasonable and are based on your common sense and experience. There are two types of evidence. One is direct evidence, such as the testimony of an eyewitness. The other is circumstantial evidence, the proof of a chain of circumstances pointing to the existence or non-existence of a certain fact. You may base your verdict on direct evidence, or on circumstantial evidence, or on both. The defense of self-defense and defense of others has been raised. A person is justified in using physical force on another person from what he reasonably believes to be the use or imminent use of unlawful physical force. In defending, a person may only use that degree of force which he reasonably believes to be necessary. A defendant who raises the defense of self-defense and defense of others has the right to have the jury consider the circumstances surrounding the event from the defendant's point of view. The paramount issue in considering self-defense and defense of others is what the defendant reasonably believed at the time he used physical force. Ordinarily, a person is not justified in using physical force on another person if he was the initial aggressor. However, the defendant's use of physical force may be justified even though he was the aggressor if you find that he withdrew from the encounter and effectively communicated to the other person an intent to withdraw from the encounter, but the other person nevertheless continued or threatened to continue the use of unlawful physical force on the defendant. Mere words and words alone, if unaccompanied by an overt act of hostility, will not cause a person to become an initial aggressor. Accompanied means being present or occurring at the same time as something else. A person is not justified in using physical force on another person if the physical force involved was the product of combat by mutual agreement, not specifically authorized by law. The burden is on the state to prove beyond a reasonable doubt that self-defense or defense of others does not apply. We are about to discuss the actual charges. During the course of this trial, you have heard evidence relating to allegations on two different dates, August 15th, 2020 and August 22nd, 2020. It is important for you to understand how you may use evidence from August 15th, 2020 with regard to evidence from August 22nd, 2020. First, you may not consider evidence from August 15th, 2020 as evidence that defendant is guilty of the crimes alleged on August 22nd, 2020. Similarly, you may not use or consider evidence from August 22nd, 2020 as evidence that defendant is guilty of the crimes alleged on August 15th, 2020. Second, you may consider the evidence of August 15th, 2020 when considering whether the state has disproven beyond a reasonable doubt the defense of self-defense or defense of others. The evidence from August 15th, 2020 may be used when considering the allegations on either August 15th, 2020 or August 22nd, 2020. On the other hand, you may not consider the evidence from August 22nd, 2020 to consider whether the state has disproven beyond a reasonable doubt the defense of self-defense or defense of others with regard to the allegations on August 15th, 2020. As you review the exhibits in this case, some are obviously related to one specific incident. Those exhibits are evidence and must be limited in their use as I've outlined above. Other exhibits more generally address plans or motive for both dates, and you may consider them for that purpose as to either incident. Specifically, those exhibits are 5, 6, 7, 90, 91, 100, 101, 102, and 204. Count 1, attempted assault in the 4th degree. Oregon law provides that a person commits the crime of attempted assault in the 4th degree if the person intentionally attempts to cause physical injury to another. In this case, to establish the crime of attempted assault in the 4th degree, the state must prove beyond a reasonable doubt the following elements. 1. The act occurred on or about August 15, 2020. 2. Alan Swinney intentionally attempted to cause physical injury to another person. And 3. Alan Swinney was not acting in self-defense or defense of others. A person attempts to commit a crime when he intentionally engages in conduct that constitutes a substantial step toward the commission of a crime in which he intends to take part personally. A substantial step is more than mere preparation. A substantial step means that the defendant's conduct would or does advance the criminal purpose of the crime charged and provides some verification of the existence of the criminal purpose. A person acts intentionally when that person acts with a conscious objective to cause a particular result or engage in particular conduct. When used in the phrase intentionally attempted to cause physical injury to another person, intentionally means the defendant acted with a conscious objective to cause physical injury to another person. When used in the phrase intentionally engages in conduct that constitutes a substantial step toward the commission of a crime in which the defendant intends to take part personally, intentionally means the defendant acted with a conscious objective to engage in conduct that constituted a substantial step towards the commission of a crime in which the defendant intended to take part personally. Count 2, unlawful use of mace in the 2nd degree. Oregon law provides that a person commits the crime of unlawful use of mace in the 2nd degree if the person recklessly discharges mace against another person. In this case, to establish the crime of unlawful use of mace in the 2nd degree, the state must prove beyond a reasonable doubt the following elements. 1. The act occurred on or about August 15, 2020. 2. Alan Swinney recklessly discharged mace or similar deleterious agent against another person. And 3. Alan Swinney was not acting in self-defense or defense of others. A person acts recklessly if that person is aware of and consciously disregards a substantial and unjustifiable risk that a particular result will occur. The risk must be of such nature and degree that disregarding it constitutes a gross deviation from the standard of care that a reasonable person would observe in the situation. When used in the phrase recklessly discharged mace or similar deleterious agent against another person, recklessly means that the defendant was aware of and consciously disregarded a substantial and unjustifiable risk that the discharged mace or similar deleterious agent would be discharged against another person. The risk must be of such nature and degree that disregard thereof constitutes a gross deviation from the standard of care that a reasonable person would observe in the situation. Count 3, attempted assault in the 2nd degree. Oregon law provides that a person commits the crime of attempted assault in the 2nd degree if the person intentionally attempts to cause physical injury to another by use of a dangerous or deadly weapon. In this case, to establish attempted assault in the 2nd degree, the state must prove beyond a reasonable doubt the following elements. 1. The act occurred on or about August 15th, 2020. 2. Alan Swinney intentionally attempted to cause physical injury to another person by means of a dangerous weapon, to wit, a paintball gun. 3. The paintball gun used by Alan Swinney was a dangerous weapon. 4. Alan Swinney intended to use the paintball gun as a dangerous weapon. And 5. Alan Swinney was not acting in self-defense or defense of others. A person attempts to commit a crime when he intentionally engages in conduct that constitutes a substantial step toward the commission of a crime in which he intends to take part personally. A substantial step is more than mere preparation. A substantial step means that the defendant's conduct would or does advance the criminal purpose of the crime charged and provide some verification of the existence of the criminal purpose. A person acts intentionally when that person acts with a conscious objective to cause a particular result or engage in particular conduct. When used in the phrase intentionally attempted to cause physical injury to another person by means of a dangerous weapon, to wit, a paintball gun, intentionally means the defendant acted with a conscious objective to cause physical injury to the other person with a paintball gun. When used in the phrase intended to use the paintball gun as a dangerous weapon, intended means the defendant acted with a conscious objective to use the paintball gun as a dangerous weapon. When used in the phrase intentionally engages in conduct that constitutes a substantial step towards the commission of a crime in which the defendant intends to take part personally, intentionally means the defendant acted with a conscious objective to engage in conduct that constituted a substantial step towards the commission of a crime in which the defendant intended to take part personally. A dangerous weapon is any weapon, device, instrument, material, or substance which, under the circumstances in which it is used, attempted to be used, or threatened to be used, is readily capable of causing death or serious physical injury. The term physical injury means an injury that impairs a person's physical condition or causes substantial pain. An injury impairs a person's physical condition if it results in a reduction in the person's ability to use the body or a bodily organ, or if it results in a reduction in a bodily organ's ability to perform its ordinary function. Substantial pain refers to both the degree and the duration of the pain. Pain is substantial if it is ample or considerable and the duration of the pain was not fleeting or consequential. The term serious physical injury means physical injury which creates a substantial risk of death or which causes serious and protracted disfigurement, protracted impairment of health, or protracted loss or impairment of the function of any bodily organ. Count 4, unlawful use of a weapon. Oregon law provides that a person commits the crime of unlawful use of a weapon if the person possesses, with the intent to use unlawfully against another, any dangerous weapon. In this case, to establish the crime of unlawful use of a weapon, the state must prove beyond a reasonable doubt the following elements. 1. The act occurred on or about August 15, 2020. 2. Alan Swinney possessed with intent to use unlawfully against another person a dangerous weapon, to wit, a paintball gun. 3. Alan Swinney intended to use the paintball gun as a dangerous weapon. And 4. Alan Swinney was not acting in self-defense or defense of others. A person acts intentionally when that person acts with a conscious objective to engage in particular conduct. When used in the phrase possessed with intent to use unlawfully against another person a dangerous weapon, to wit, a paintball gun, with intent means that the defendant possessed a dangerous weapon with a conscious objective to use it unlawfully against another person, and that the defendant had the conscious objective to use the paintball gun as a dangerous weapon. When used in the phrase use unlawfully against another person, the term use refers to employment of a weapon to inflict harm or injury, or employment of a weapon to threaten immediate harm or injury. A dangerous weapon is any weapon, device, instrument, material, or substance which, under the circumstances in which it is used, attempted to be used, or threatened to be used, is readily capable of causing death or serious physical injury. The term serious physical injury means physical injury which creates a substantial risk of death or which causes serious and protracted disfigurement, protracted impairment of health, or protracted loss or impairment of the function of any bodily organ. Count 5, assault in the second degree. Oregon law provides that a person commits the crime of assault in the second degree if the person intentionally or knowingly causes physical injury to another by use of a dangerous weapon. In this case, to establish assault in the second degree, the state must prove beyond a reasonable doubt the following elements. 1. The act occurred on or about August 15, 2020. 2. Alan Swinney intentionally or knowingly caused physical injury to Jason Britton by means of a dangerous weapon, to wit, a paintball gun. 3. The paintball gun used by Alan Swinney was a dangerous weapon. 4. Alan Swinney intended to use or knowingly use the paintball gun against Jason Britton as a dangerous weapon. And 5. Alan Swinney was not acting in self-defense or defense of others. A person acts intentionally when that person acts with a conscious objective to cause a particular result or engage in particular conduct. When used in the phrase intentionally caused physical injury to Jason Britton by means of a dangerous weapon, to wit, a paintball gun, intentionally means the defendant acted with a conscious objective to cause a particular result, physical injury, by means of a dangerous weapon. When used in the phrase intended to use the paintball gun against Jason Britton as a dangerous weapon, intended means the defendant had a conscious objective to use the paintball gun as a dangerous weapon. In the context of this count, you will be asked to consider whether the concept of transferred intent applies. Transferred intent applies when a person unlawfully and intentionally attempts to injure another, but the shot or blow takes effect upon and causes injury to someone else instead. In that situation, the person's intent to injure the intended victim is transferred to the victim who was actually injured. In other words, the identity of the victim is immaterial if the intent to injure is established and an injury to a person results. However, just as intent transfers, so too do defenses. So the state must still prove beyond a reasonable doubt that the defenses of self-defense or defense of others did not justify the defendant's use of force. In order to reach a lawful verdict as to this count, you must unanimously agree on whether or not the state has proved this count under the concept of transferred intent, or that the defendant intentionally or knowingly injured Mr. Britton. A person acts knowingly when that person acts with an awareness that his conduct is of a particular nature. When used in the phrase knowingly caused physical injury to Jason Britton by means of a dangerous weapon, to wit, a paintball gun, knowingly means that the defendant acted with an awareness that his conduct was assaultive in nature against Jason Britton. When used in the phrase knowingly use the paintball gun against Jason Britton as a dangerous weapon, knowingly means that the defendant acted with an awareness that the paintball gun was a dangerous weapon. A dangerous weapon is any weapon, device, instrument, material, or substance which, under the circumstances in which it is used, attempted to be used, or threatened to be used, is readily capable of causing death or serious physical injury. The term physical injury means an injury that impairs a person's physical condition or causes substantial pain. An injury impairs a person's physical condition if it results in a reduction in the person's ability to use the body or a bodily organ, or if it results in a reduction in a bodily organ's ability to perform its ordinary function. Substantial pain refers to both the degree and the duration of the pain. Pain is substantial if it is ample or considerable, and the duration of the pain was not fleeting or consequential. The term serious physical injury means physical injury which creates a substantial risk of death or which causes the serious and protracted disfigurement, protracted impairment of health, or protracted loss or impairment of the function of any bodily organ. All right, we are now moving on to the events of August 22nd. Count 6, assault in the second degree. Oregon law provides that a person commits the crime of assault in the second degree if the person intentionally or knowingly causes physical injury to another by use of a dangerous weapon. In this case, to establish assault in the second degree, the state must prove beyond a reasonable doubt the following elements. 1, the act occurred on or about August 22nd, 2020. 2, Alan Swinney intentionally or knowingly caused physical injury to Ms Stewart by means of a dangerous weapon, to wit, a paintball gun. 3, the paintball gun used by Alan Swinney was a dangerous weapon. And 4, Alan Swinney intended to use or knowingly use the paintball gun against Ms Stewart as a dangerous weapon. A person acts intentionally when that person acts with a conscious objective to cause a particular result or engage in particular conduct. When used in the phrase intentionally caused physical injury to Ms Stewart by means of a dangerous weapon, to wit, a paintball gun, intentionally means the defendant acted with a conscious objective to cause a particular result, physical injury by means of a dangerous weapon. When used in the phrase intended to use the paintball gun against Megan Stewart as a dangerous weapon, intended means the defendant had a conscious objective to use the paintball gun as a dangerous weapon. A person acts knowingly when that person acts with an awareness that his conduct is of a particular nature. When used in the phrase knowingly caused physical injury to Megan Stewart by means of a dangerous weapon, to wit, a paintball gun, knowingly means that the defendant acted with an awareness that his conduct was assaultive in nature against Megan Stewart. When used in the phrase knowingly use the paintball gun against Megan Stewart as a dangerous weapon, knowingly means that the defendant acted with an awareness that the paintball gun was a dangerous weapon. A dangerous weapon is any weapon, device, instrument, material, or substance which, under the circumstances in which it is used, attempted to be used, or threatened to be used, is readily capable of causing death or serious physical injury. The term physical injury means an injury that impairs a person's physical condition or causes substantial pain. An injury impairs a person's physical condition if it results in a reduction in the person's ability to use the body or a bodily organ, or if it results in a reduction in a bodily organ's ability to perform its ordinary function. Substantial pain refers to both the degree and the duration of the pain. Pain is substantial if it is ample or considerable, and the duration of the pain was not fleeting or consequential. The term serious physical injury means physical injury which creates a substantial risk of death or which causes serious and protracted disfigurement, protracted impairment of health, or protracted loss or impairment of the function of any bodily organ. Count 7, unlawful use of a weapon. Oregon law provides that a person commits the crime of unlawful use of a weapon if the person possesses, with the intent to use unlawfully against another, any dangerous weapon. In this case, to establish the crime of unlawful use of a weapon, the state must prove beyond a reasonable doubt the following elements. 1, the act occurred on or about August 22nd, 2020. 2, Alan Swinney possessed with intent to use unlawfully against another person a dangerous weapon, to wit, a paintball gun. 3, Alan Swinney intended to use the paintball gun as a dangerous weapon. And 4, Alan Swinney was not acting in self-defense or defense of others. A person acts intentionally when that person acts with a conscious objective to engage in particular conduct. When used in the phrase possessed with intent to use unlawfully against another person a dangerous weapon, to wit, a paintball gun, with intent means that the defendant possessed a dangerous weapon with a conscious objective to use it unlawfully against another person, and that the defendant had the conscious objective to use the paintball gun as a dangerous weapon. When used in the phrase use unlawfully against another person, the term use refers to employment of a weapon to inflict harm or injury, or employment of a weapon to threaten immediate harm or injury. A dangerous weapon is any weapon, device, instrument, material, or substance which, under the circumstances in which it is used, attempted to be used, or threatened to be used, is readily capable of causing death or serious physical injury. The term serious physical injury means physical injury which creates a substantial risk of death or which causes serious and protracted disfigurement, protracted impairment of health, or protracted loss or impairment of the function of any bodily organ. Count 8, unlawful use of a weapon with a firearm. Oregon law provides that a person commits the crime of unlawful use of a weapon if the person possesses with the intent to use unlawfully against another any dangerous weapon. In this case, to establish the crime of unlawful use of a weapon, the state must prove beyond a reasonable doubt the following elements. 1, the act occurred on or about August 22nd, 2020. 2, Alan Swinney possessed with intent to use unlawfully against another person a deadly or dangerous weapon, to wit, a revolver. 3, Alan Swinney intended to use the revolver as a deadly or dangerous weapon. And 4, Alan Swinney was not acting in self-defense or defense of others. A person acts intentionally when that person acts with a conscious objective to engage in particular conduct. When used in the phrase possessed with intent to use unlawfully against another person a dangerous weapon, to wit, a revolver, with intent means that the defendant possessed a deadly or dangerous weapon with a conscious objective to use it unlawfully against another person, and that the defendant had the conscious objective to use the revolver as a deadly or dangerous weapon. When used in the phrase use unlawfully against another person, the term use refers to employment of a weapon to inflict harm or injury, or employment of a weapon to threaten immediate harm or injury. A deadly weapon means any instrument, article, or substance specifically designed for and presently capable of causing death or serious physical injury. A dangerous weapon is any weapon, device, instrument, material, or substance which, under the circumstances in which it is used, attempted to be used, or threatened to be used, is readily capable of causing death or serious physical injury. The term serious physical injury means physical injury which creates a substantial risk of death or which causes serious and protracted disfigurement, protracted impairment of health, or protracted loss or impairment of the function of any bodily organ. If and only if you conclude that Alan Swinney is guilty of count 8, you must then determine whether the state has proven beyond a reasonable doubt the additional following allegation. During the commission of count 8, Alan Swinney used and threatened the use of a firearm. A firearm is a weapon by whatever name known that is designed to expel a projectile by the action of powder. Count 9, menacing. Oregon law provides that a person commits the crime of menacing if by word or conduct the person intentionally attempts to place another person in fear of imminent serious physical injury. In this case, to establish the crime of menacing, the state must prove beyond a reasonable doubt the following elements. 1. The act occurred on or about August 22nd, 2020. 2. Alan Swinney intentionally attempted by word or conduct to place another person in fear of imminent serious physical injury by pointing a firearm at them. And 3. Alan Swinney was not acting in self-defense or defense of others. A person acts intentionally when that person acts with a conscious objective to cause a particular result or engage in particular conduct. When used in the phrase intentionally attempted by word or conduct to place another person in fear of imminent serious physical injury by pointing a firearm at them intentionally means that the defendant acted with a conscious objective to place another person in fear of imminent serious physical injury when they pointed a firearm at them. Imminent means near at hand or impending. Serious physical injury means physical injury, which creates a substantial risk of death or which causes serious and protracted disfigurement, protracted impairment of health, or protracted loss or impairment of the function of any bodily organ. Count 10, pointing a firearm at another. Oregon law provides that a person over the age of 12 years commits the crime of pointing a firearm at another when the person, with or without malice, intentionally points or aims a loaded or empty pistol, revolver at or toward any other person within the range of the firearm unless the person is acting in self-defense. In this case, to establish the crime of pointing a firearm at another, the state must prove beyond a reasonable doubt the following elements. 1. The act occurred on or about August 22nd, 2020. 2. At the time of the offense, Alan Swinney was over 12 years of age. 3. Alan Swinney intentionally pointed or aimed a loaded or empty pistol, revolver at or toward another person. 4. The other person was within range of the firearm. And 5. Alan Swinney was not acting in self-defense or defense of others. A person acts intentionally when that person acts with a conscious objective to cause a particular result or engage in particular conduct. When used in the phrase intentionally pointed or aimed a loaded or empty pistol, revolver at or toward another person, intentionally means that the defendant acted with a conscious objective to point or aim a loaded or empty pistol, revolver at or another person. A firearm is a weapon by whatever name known that is designed to expel a projectile by the action of gunpowder. Count 11, unlawful use of mace in the second degree. Oregon law provides that a person commits the crime of unlawful use of mace in the second degree if the person recklessly discharges mace against another person. In this case, to establish the crime of unlawful use of mace in the second degree, the state must prove beyond a reasonable doubt the following elements. 1. The act occurred on or about August 22nd, 2020, and 2. Alan Swinney recklessly discharged mace or similar deleterious agent against Ms Stewart. A person acts recklessly if that person is aware of and consciously disregards a substantial and unjustifiable risk that a particular result will occur. The risk must be of such nature and degree that disregarding it constitutes a gross deviation from the standard of care that a reasonable person would observe in the situation. When used in the phrase recklessly discharged mace or similar deleterious agent against Ms Stewart, recklessly means that the defendant was aware of and consciously disregarded a substantial and unjustifiable risk that the discharged mace or similar deleterious agent would be discharged against Megan Stewart. The risk must be of such nature and degree that disregard thereof constitutes a gross deviation from the standard of care that a reasonable person would observe in the situation. Count 12, assault in the fourth degree. Oregon law provides that a person commits the crime of assault in the fourth degree if a person intentionally, knowingly, or recklessly causes physical injury to another. In this case, to establish the crime of assault in the fourth degree, the state must prove beyond a reasonable doubt the following elements. 1, the act occurred on or about August 22nd, 2020, and 2, Alan Swinney intentionally, knowingly, or recklessly caused physical injury to Megan Stewart. A person acts intentionally when that person acts with a conscious objective to cause a particular result or engage in particular conduct. When used in the phrase intentionally caused physical injury to Megan Stewart, intentionally means that the defendant acted with a conscious objective to cause physical injury to Megan Stewart. A person acts knowingly if that person acts with an awareness that his conduct is of a certain nature. When used in the phrase knowingly caused physical injury to Megan Stewart, knowingly means that the defendant acted with an awareness that his conduct would result in physical injury to Megan Stewart. A person acts recklessly if that person is aware of and consciously disregards a substantial and unjustifiable risk that a particular result will occur. The risk must be of such nature and degree that disregarding it constitutes a gross deviation from the standard of care that a reasonable person would observe in the situation. When used in the phrase recklessly caused physical injury to Megan Stewart, recklessly means that the defendant was aware of and consciously disregarded a substantial and unjustifiable risk that Megan Stewart will be physically injured as a result of the person's actions. The risk must be of such nature and degree that disregard thereof constitutes a gross deviation from the standard of care that a reasonable person would observe in the situation. The term physical injury means an injury that impairs a person's physical condition or causes substantial pain. An injury impairs a person's physical condition if it results in a reduction in the person's ability to use the body or a bodily organ, or if it results in a reduction in a bodily organ's ability to perform its ordinary function. Substantial pain refers to both the degree and duration of the pain. Pain is substantial if it is ample or considerable, and the duration of the pain was not fleeting or consequential. And members of the jury, despite the fact that the attorneys and I went through this morning and over the weekend, I have just realized we are missing one instruction. I'm going to read it to you now. Actually, I'm going to print it out for you first, and then I'm going to read it to you. So bear with me for one moment, please, as I try to find a copy of the document with the language in it. Actually, I'm just going to type it really quickly because that's going to be faster, I think. So everyone, please feel free to stand up and stretch while I get this added. to you. I suppose if there was going to be one that was separate from the rest, this is the best one for it to be separate from the rest. So as soon as Mr. Keenan gets it printed out, we'll get it out to you all, and then I'll finish reading the instructions.
But the east is where I am.
Thank you, sir.
All right, now that all of you have it. Innocence of the defendant, proof beyond a reasonable doubt. Kind of an important one to tell you about. The defendant is innocent of any crime unless and until the state proves the defendant is guilty beyond a reasonable doubt. The burden is on the state to prove the guilt of the defendant beyond a reasonable doubt. Reasonable doubt means you believe there is a reasonable possibility that the defendant is not guilty. Proof beyond a reasonable doubt is proof that, after careful and impartial consideration of all of the evidence in the case, it leaves you convinced to beyond a reasonable doubt that a defendant is guilty. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. The standard is not beyond all doubt, but beyond a reasonable doubt. I mentioned at the beginning of the trial that other standards exist in our legal system. For example, in civil cases for damages, the burden of proof is preponderance of the evidence, which means more likely than not. Another standard, clear and convincing evidence, means highly probable. Clear and convincing evidence is the burden of proof in civil fraud cases and when punitive damages are claimed. Proof beyond a reasonable doubt is a higher standard than both the preponderance standard and the clear and convincing standard. It is the highest standard of proof we use in our courts. If, based on your careful consideration of all the evidence, you are not convinced beyond a reasonable doubt that the defendant is guilty of the crime charged, I'm going to ask you all to put a little caret in there and write in between you are not convinced beyond a reasonable doubt that the defendant is guilty of the crime charged. You may, no, it's you are convinced. I'm so sorry, ladies and gentlemen. If, based on your careful consideration of all the evidence, you are convinced beyond a reasonable doubt that the defendant is guilty of the crime charged, you may return a verdict of guilty. If, on the other hand, you think there is a reasonable possibility that the defendant is not guilty, you must return a verdict of not guilty. So, after closing arguments, what we're going to do is send you all back to the 2 separate jury deliberation rooms for a few moments while we clear out of here. And then Mr. Keenan will bring you back into this courtroom to deliberate so that you can still be socially distant as you deliberate. As you begin deliberations, select one of your members to act as presiding juror. The presiding juror has no greater voting weight, but is to preside over your deliberations and be the spokesperson for the jury. You should then deliberate and find your verdict. If it becomes necessary during your deliberations to communicate with me, do so in writing. I will consult with the parties before responding. No one except for you, the jurors, is to be involved in your deliberations. Therefore, do not tell anyone, including me, how many of you are voting not guilty or guilty until you have reached a lawful verdict or have been discharged. Guilty verdicts must be unanimous, which means that each and every juror must agree on a guilty verdict. But not guilty verdicts may be non-unanimous. At least 10 jurors must agree on a not guilty verdict. So if you are divided 9-3, for example, you do not have a not guilty verdict. The rule is different regarding the alleged additional fact of regarding the use of a firearm in count 8, which you will decide only if you reach a guilty verdict in that count first. In order to answer yes, that an additional fact has been proved, all jurors must agree that the additional fact has been proved beyond a reasonable doubt. However, if any jurors find that the additional fact has not been proved beyond a reasonable doubt, the answer would be no. For example, if you are divided 11-1 in favor of an additional fact, you do have an answer on that fact, an answer of no. When you have arrived at a verdict, the presiding juror will complete and sign the appropriate verdict form. After you have reached your verdict, signal Mr. Keenan. The court will then receive your verdict. So I've attached a copy of the verdict form, and you'll see that they are listed by count, and then we've attempted to give you just a little information to refresh your recollections as to each count. I want to highlight 2 counts in particular for you all. As I mentioned in the instructions on count 5, you're being asked to decide which theory the state has proved Mr. Swinney guilty, if at all. So you will first decide whether or not he intentionally or knowingly caused physical injury to Jason Britton by means of a dangerous weapon, to wit, a paintball gun, or that he intended to cause physical injury to an unidentified person by means of a dangerous weapon, to wit, a paintball gun, and Jason Britton was injured. So there has to be concurrence. All of you must agree on which theory applies in this case. This courtroom is closed to the public. Thank you. And then on count 8, unlawful use of a weapon with a firearm. Just a reminder that there is the additional question: did the defendant use or threaten the use of a firearm during the commission of count 8? And you will answer yes or no if and only if you have found Mr. Swinney guilty of count 8. All right. With that, we turn it over to the state for its closing argument.
Thank you, Your Honor, and I think I'll need Mr. Keenan to throw the PowerPoint on the screen, but other than that, we're ready.
Sure, that's far more advanced than the court can do itself. It is not. Are you table?
Maybe 2?
3 or 4? There we go. Thank you. In August 2020, last year, Alan Swinney came to downtown Portland with a plan. He was motivated, he was fueled by a hatred for the left and for Antifa. And in pursuit of that motivation, he had a plan to bring violence to those who he perceived as Antifa or the left. He was, as he told you on Friday, tired of seeing what he'd seen on TV, and he felt he needed to do something about it. What was he bringing? Well, he told us, and he told the world. He said, this isn't turning into a civil war, it is a civil war. He was not planning to bring a civil discourse to our city. He was not coming to counter the words or the actions of others with peaceful commentary. He was bringing a civil war, his civil war, to Portland. And he described it as the last crusade. It has already started there on July 7th. He continued, and he brought that crusade here. Moreover, he didn't just come alone. He called for boots on the ground to be the absolute tip of the spear, the right's answer to the left's violence. Again, the plan was not to come here and stand peacefully in the way of what he saw as the destruction from a mob, as he described it. He wanted to be the right's answer to the left's violence. And indeed, he said more about his plan in a recorded conversation that we can hear.
Right, we're all the right. Yeah, right in the middle. Right in the middle. I mean, there's been other flag waves there, right? But it hasn't been me there. And Enrique didn't know the people that done flag waves. So it's gonna be more than a normal flag wave that they do down there. But still, those other people have people coming up screwing with them and like knocking their signs down and trying to. They got to keep their hands to themselves. They come up. Oh yeah, that's assault. Yeah, then that's one. And like, so then, okay, everybody needs to have their cameras rolling. If anybody gets an assault, just like yell out, "Got one!" So we'll know how many we'll have a total. If we hear 3 or 4 people say, "Got one," right? So we need to make sure we got assault. I mean, if it's a crazy assault, then yeah, first, yeah, we go first. If it's like them pushing. You know, they grab your flag or something. Yeah, just yeah, something blatant like that. Yeah, come on. Like they grab somebody. If you can restrain yourself and they didn't hurt you, they just assault you. That's one assault. Yeah, hold your flag. Wait till you see the whites of their eyes. Like, let them come here. Right. You know, and you can do that. Hopefully we got that. Hopefully we, because then it's your word. Yeah. Yeah. Like we've got it on video and stuff. We know we've got it on video. We got several of them on video. Nothing's gonna happen because we got what this show. This is all happening. This is all happening. This is all happening. And that's why
That was Mr. Swinney's plan. Come to Portland, hope, plan for what he's describing as assault. He said directly in there, that's somebody grabbing your flag. And once we get 3 or 4 of those on video, it's go time. That was the plan. Come to Portland, start a fight, and finish it. As you've heard over the course of this trial, Mr. Swinney came to downtown Portland on 2 separate occasions. The first of which, August 15th, 2020. And as we've heard plenty of evidence and seen plenty of evidence, he was dressed for battle that day, wearing what he described as body armor, riot helmet, paintball gun, loaded with paintballs. He had a large knife on his waist, cans of mace, and, important to at least the outside reason for why he and his group were there, a flag. But as he said on the stand on Friday, that flag was really a stick with a flag on it. Small flag, smaller than a piece of paper, really a stick that he could use to poke, push, and hit people with. He came dressed for battle because that was his purpose. And after they had flag wave in front of the Justice Center, relatively small, certainly compared to the next event, he and his group proceeded to leave. And as they did, we saw moment after moment, act after act, the defendant Alan Swinney acting aggressively, acting violently, and escalating every step along that path out of Portland. The first, we saw here on 2nd Avenue, this man in the yellowish-green reflector vest following him. Mr. Swinney said on the stand, man hadn't threatened him, man wasn't armed, didn't touch him. He was, in Mr. Swinney's mind, getting too close. And that's when Mr. Swinney took the first act of aggression. It sounds a little off, but what you can clearly see, the man is walking behind him. Just like a dozen or more other people walking behind him, walking to his side, walking in front of him. And out of the blue, Mr. Swinney says, nope, shoves that guy right in the face. That wouldn't be the last. A bit farther on, he again decided people are too close, whatever that means in his mind as he was walking along this path. So again, escalated the violence.
Thank you, my friend, thank you.
Whoa. Maybe unless I see one. Whoa.
Hey, point that at somebody else, motherfucker. You shoot people with a paintball gun, you think that's cool? How do you think that's legal? Look, he just shot him with that paintball gun. I got it on camera. This motherfucker's instigating. You want to keep instigating? Keep instigating. I don't give a fuck. I have every right to stand here. You're not under any threat.
Once again, an unarmed person following, doing nothing overt, nothing obvious, not even saying anything to Mr. Swinney, but he decides that person's too close. And so he shoots him. We've moved out of the realm of just using hands. Now he's using a weapon and shoots the man right in the stomach. And as you heard him testify on Friday, he chose this spot because of the the scene there, the cover that he had in his mind on this battlefield, and took an opportunity, not because anybody's doing anything particularly threatening, holding any weapons, coming at him in any particular fashion, but because he decided, again, he needed to amp up the violence, and he did. This is when
Get the fuck out of here! You don't have the right to harass people! Hands up!
sees a person standing there, shorts, t-shirt, nothing in their hands, and he says, this person needs to be maced. I need to inflict some pain on this person for no particularly good reason and no justified reason. And again, after macing that person, he escalates again when another person steps just several feet away, not in his face, not in his bubble, just stepping forward.
Back up!
Shoots him square in the head. From there, they proceeded onward. The crowd, understandably upset at this point. Mr. Britton, understandably upset at this point, having seen at least 4 people assaulted by Mr. Swinney. So they continued following, telling them to get out, to leave. Now it's at this point that essentially the only person throughout that day, through all of the video that's in evidence, the only person that's following Mr. Swinney and his group that has any kind of a perceived weapon appears. Mr. Swinney and his group deploy Mace as he's, once again, calmly walking up to them, and that person leaves. Walks out of the frame, walks out of the picture, walks out of the scene. And again, Mr. Swinney decided that more violence was necessary, that he wanted to hurt somebody else.
What are you gonna do, beat me? You gonna shoot me with your paintball gun? Fine, do it. I am not threatening you at all. So if you wanna beat me and you wanna assault me, I'll see you in court, buddy.
I'll see you in court, buddy.
Right. You shoot that right by my head? Oh, he just shot me in the eyeball. He just shot me in the fucking eyeball with a paintball.
Shooting Mr. Britton just a few feet away after he'd been telling him, I am not threatening you, leave. And eventually they did. But that wasn't the end of Mr. Swinney's time in Portland. He came back on the 22nd, and once again, he had a plan for our city. He called, he put out the call. Hundreds of patriots to converge. This is D-Day. This isn't the walk across the Edmund Pettus Bridge. This is D-Day. Telling essentially the group of people that had been protesting in Chapman Square, you have successfully removed the cops, and now you get to deal with we the people. He went further, using this ancient battle imagery from a movie, from a war movie, saying this is where we hold them, this is where we fight. Portland, Oregon, Saturday, August 22nd, at the Justice Center. Announcing his intention and calling for people to join him. Once again, he showed up ready for battle. Same things we saw on the 15th, the armor, the helmet, the knife, flagpole or the stick, paintball gun, multiple cans of mace. And this time he upped the firepower. He brought a live firearm. 357 Magnum Ruger Blackhawk, strapped right to his hip so everyone could see it. So he could have ready access to it when he felt that he could use it and get away with it. Now, as you heard from essentially all of the witnesses, states and the defense, it was a chaotic day on the 22nd. Changed through the course of the afternoon as more people arrived, people more armed, more armored arrived, as essentially, as Mr. Swinney described it, a front, the battle line was drawn. And yes, both sides were throwing things, not just words, but rocks, projectiles, things of that nature. Both sides. Mr. Swinney came, however, again, unlike the group in Chapman Square, came dressed for battle and with a group of similarly armed and armored compatriots. Again, unlike the group they're facing, we see helmets, we see guns, mace, armor. And as that day went on, Mr. Swinney would repeatedly fire his paintball gun into the crowd, repeatedly deploy mace into the crowd. We heard a little bit of what his intent was that day, or at least what his stated goal was. He clearly saw himself as some sort of makeshift one-man police force, there to enforce whatever laws he deemed necessary at the moment, whatever laws he concocted. We saw one particular incident in which this man, much like on the 15th, was just getting too close for his comfort. See throughout this, he's not holding any weapons, he's not making any threats, he is standing there passively filming with press written on his helmet there. As I said, over the course of the day, he would fire, sounds like from his testimony, hundreds, not thousands of paintballs into this crowd, based on him receiving 4,000 paintballs from his friend, Mr. Bailey. We saw him doing that. Once again, we see that his plan that day was to come and to inflict as much pain as he could to what he saw as the other side. In that video, you can even see, right around the middle portion there, it actually appears that he's pointing it straight at the camera, the person who's standing there filming. Once again, no threat, no weapons, firing at as many people, inflicting as much pain as he can. Again, he continued. round after round, shot after shot, paintball after paintball into a crowd that all of the witnesses described as having observers, people in shorts, t-shirts, casual clothes, there to see what was happening this day. Peaceful protesters, again, people unarmed, unarmored, there to stand for what they believe in, not to engage in violence. And yes, there were people there in all black, helmets, gas masks, and umbrellas. And among the people that he fired at that day and struck was Ms. Stewart. She told you she was there essentially as an observer. Not there to make a political point, certainly not there to harm anybody, threaten anybody. Walking through the crowd about 15, 20 feet back from the sidewalk, she catches one of Mr. Swinney's paintballs. He testified that he fired it. She saw him, noticeable guy, bigger than anybody else in the group, fired it straight at her, struck her in the chest. We also heard from Brittany Carell, one of the peaceful protesters. No evidence that she ever took a swing or threatened a single person that day. And yet this was the same person that testified that Mr. Swinney looked straight at her, said, "I'll fuck you up, sweetheart." Just for being there. Standing up for what she believed in. And she testified that later on that day, she would see Mr. Swinney pull out that handgun, pointed at her, the people she was with, none of whom were posing a threat to him. She was scared for her life, as anyone would be, looking down the barrel of his .357 Magnum. And then lastly, you heard from Ms. Stewart that on his way out, he was standing there after having been shot by him with the paintball. After trying to get a better view of him, she tried to just leave. Came upon him again by chance, having been apparently marked by him, took his mace, and sprayed her right in the face. Those are the events of August 15th and August 22nd that bring us here today and that you'll be deliberating about once closing arguments are finished. I want to go through in a little bit of detail the charges, the elements, to make sure that it's clear to you why the state has proved beyond a reasonable doubt each and every charge in this case. I want to start with some of the recurring elements, especially for the assault charges and the unlawful use of a weapon, or I've shortened it to UUW there. The first that you're going to see repeated is physical injury. Now, the judge just told you that physical injury is an injury that impairs a person's physical condition or, so there's three here: dangerous weapon and intent. Physical injury is an injury that impairs a person's physical condition or causes substantial pain. And that pain the substantial pain refers both to the degree and the duration of the pain, and it is substantial if it is ample and considerable, and the duration was not fleeting or inconsequential. The injuries in this case were neither fleeting nor inconsequential, and both of the victims who were harmed told you that they had pain and injury that lasted for weeks. You saw and heard from Ms. Stewart that she got hit in the breast, that she had pain there for a week. She couldn't even put on a bra for that week, and it continued. That pain, bruise, the welt, caused by Mr. Swinney's paintball. You heard and you can see on Mr. Britton the injury to his eye. How he told you that that pain lasted at least a week, that he was sensitive to light. He couldn't even open his eyes for a month without feeling pain from that sensitivity. And you heard him tell you that to this day, more than a year later, he still cannot see as he once could. Those are both physical injury under the definition. You also heard about mace being used, and you heard each of the witnesses who came into contact with it, about everybody that day did. You heard that it causes the burning of the eyes, difficulty breathing. Ms. Stewart said she went and vomited from the effects of this bear mace. Sore throat. You heard that these went on for hours, the effects of the bear mace. That is enough for physical injury under the law. Moving on to the dangerous weapon element. That is any weapon, device, or instrument that under the circumstances in which it is used, attempted to be used, or threatened to be used, is readily capable of causing death or serious physical injury. I'm going to start with the easy one. A firearm is obviously a dangerous weapon. In fact, it is a deadly weapon. It's an instrument specifically designed for and presently capable of causing death or serious physical injury. And in this case, the defendant admitted real firearm, real bullets, loaded, finger on the trigger, and the hammer cocked back. That is an instrument designed for and presently capable of causing death or serious physical injury. But moving on to the less conventional weapon, maybe a weapon that not everybody would immediately think of in that definition, but which very much fits the law of dangerous weapon. Importantly, you look to the definition here. Under the circumstances in which it is used, it is capable of causing serious injury, which is serious and protracted disfigurement, protracted impairment of health, or protracted loss or impairment of a function of a bodily organ. One of the things to keep in mind is it is the circumstances in which it is used. So is a paintball gun going to be a dangerous weapon in every circumstance and in every way that it is used? No. Like a stick or a baseball bat. It's not a weapon in every instance in which it is used. But what were the circumstances in which Mr. Swinney used the paintball gun? Well, the circumstances of the 3 times that he's charged with using that paintball gun were in extremely short range, toward unprotected eyes and faces, heads, or both. Ms. Stewart was shot wearing nothing more than a cloth COVID mask, no goggles, no helmet. In that circumstance and in the way the paintball gun was used, it was capable of hitting her in the eye, just like it hit Mr. Britton in the eye. And she could have easily had not just the physical pain and the physical injury from being shot in the chest, she could have had the same kinds of injuries, long-lasting impairment that Mr. Britton had. And it's only by chance that it hit her chest, not her face, her eyes, her mouth, her nose, her ears. This person that he shot, again, extremely close range, just a few feet away, and straight to the head. Now you'll have the videos with you in the jury room, and you should review those and see that he is clearly aiming for this person's head. And in those circumstances, and in the way that he used it, it was readily capable of striking places on his mouth that could be impaired for a long duration. And if you review the video, you will see that he struck in the head. In those circumstances, that weapon is being used as a dangerous weapon. And lastly, the assault against Mr. Britton. Again, extremely close range. And in that case, he is wearing no protection whatsoever. And he paid the price for that. The third element that I want to go over with you that recurs throughout the charges is the element of intent. Here a person acts, you've heard the judge describe it multiple times. Intent can be a tricky element because we don't have a window into Mr. Swinney's mind. We can't look back and say with certainty the precise thoughts in his head. But in this case, we have a pretty good idea. Because actions speak louder than words. When he's shooting this man in the belly and spraying this person with mace, he's showing his intent. It's not a mystery that he's intending to hurt those people, to cause that injury, to cause them discomfort, to get them away from him using pain. His intent is clear. His intent was clear when he shot the second person. His intent was clear. And on the 22nd, once again, by his own actions that you can see plain as day, his intent is clear. He's firing his paintball gun into the crowd, firing it at the likes of Ms. Stewart. And his intent is clear. Lastly, when he pulled out that firearm, cocked the trigger, cocked the hammer, and put his finger on the trigger, his intent was clear. Threaten, be prepared to shoot, or at the very least, scare the daylights out of anybody in that crowd. Anybody and everybody. But in addition to his actions, we can look to his own words. He testified on Friday, saying, since we're not the cops, they may think there's no repercussions for their actions, and I was trying to make them understand that there is. His intent, not to defend himself, not just to get people to move away from him. His intent was to show these people that there are repercussions, and he was going to deliver those repercussions. He said, I don't feel bad for them when this bad stuff happens to them. The karma bus came and hit them. He saw himself as that karma bus. Later on, or beforehand, we saw that his intent was formed before he even arrived. Once again, his intent was not to show up for a peaceful demonstration. His intent was to fight. And when he fired in each of those times, you can tell what his intent was. And as he described it later on, he said what his intent was. He described shooting Mr. Britton as teaching him a life lesson. That shows his intent. I'm going to go through in some detail now each of the charges. I've grouped them not in the order of the counts, but by the types of charges, just for sake of clarity. So I'm going to start with number 5. This is the assault in the second degree against Mr. Britton. The elements begin that the act occurred on or about August 15th. There's no dispute, there's no doubt that this occurred on August 15th. And second, that he intentionally or knowingly caused physical injury to Mr. Britton by means of a dangerous weapon, in this case a paintball gun. Again, as I've described, the physical injury that he caused to Mr. Britton is obvious. The nature of the paintball gun as a dangerous weapon is clear. So the question in this element is, did he intend to shoot Mr. Britton? And the state would suggest, yes, he did intend to shoot Jason Britton. How do we know? Well, he said it before he even did it. Britton asked him, "You want to shoot me with that paintball gun?" He said, "Yeah, kind of do." Later on, he pointed it straight at Mr. Britton. You can see, if you slow down those frames, you can see him point the gun at Mr. Britton. And clearly, he did point it at Mr. Britton because he shot him in the eye. He was clearly angry and upset with Mr. Britton. We heard from Mr. Swinney that he didn't hear Mr. Britton telling him, "I'll see you in court. You want to assault me, you want to shoot me with a paintball gun, I'll see you in court." But if you watch it again, you can clearly see before that, looking over his shoulder, but when Mr. Britton says that, he turns around and stares at him square in the eyes. Jason Britton was pissing him off. He'd been talking at him, yelling at him, calling him names for the entire procession. So he was mad, and he wanted to get back. He wanted to show there were repercussions and teach a life lesson. But even if you are not convinced that he was intending to shoot Mr. Britton, that he was instead trying to shoot the person behind him, we have the theory of transferred intent, the law of transferred intent. And this tells you that in a situation, the person's intent to injure the intended victim is transferred to the victim who is actually injured. By his own words on the stand, on Friday, Mr. Swinney told you that he was intending to shoot the person behind Mr. Britton. Him right here. And again, the intent is pretty clear when you're firing at close range repeatedly at this person who has apparently a gas mask or goggles. The intent there is to cause pain. Why did he want to cause him pain? Well, he said it was because the man was getting too close. He was sneaking up. Not that he was threatening, assaulting, touching, anything like that. He wanted him to move back, so he intended to cause him pain, and he did, firing several rounds. So, even if you do not believe beyond a reasonable doubt that Mr. Britton was his intended target, the fact that he intended to shoot the man behind him is enough for you to transfer that intent to Mr. Britton, subject to the self-defense, that I'm going to get to in just a bit. Moving on to paintball gun, we have to prove that the paintball gun used by Mr. Swinney was a dangerous weapon. Again, that's been made clear. He intended to use or knowingly use the paintball gun against Mr. Britton as a dangerous weapon. Well, he told you on Friday, yes, he knows that a paintball gun can cause someone serious physical injury, especially used at close range. If somebody doesn't have a mask or protective gear. That element is clear. I'm going to deal with self-defense in detail in a little bit, but the state also has to disprove that the idea that this was done in self-defense, and indeed this was not done in self-defense, and the state has proved that beyond a reasonable doubt. But for now, I want to move on to the count number 6, the assault against Ms. Stewart. On this, we have to prove that the event occurred on August 22nd. Again, no doubt, no argument there. And that he intentionally and knowingly caused physical injury to her by means of a dangerous weapon. Again, she testified he pointed straight at her, fired, and it caused her that physical injury that you saw. What had he done before that day? He put a laser sight on the paintball gun. Wanted to increase his accuracy. In response to a question on cross-examination, he said yes, he sighted it in to make sure he was being accurate. Knew what he was doing. He was intending to shoot the people that he shot that day, marking them, as he said, for later. Again, paintball gun, dangerous weapon, and that he intended it as a dangerous weapon, again, to cause pain to those people that he saw as being agitators, nuisance, the left. Moving on to And important to note here, self-defense is not at issue with Ms. Stewart. So for the charges against Mr. Swinney for shooting Ms. Stewart with the paintball gun and the mace, self-defense is not at issue. The only question is whether the state proved that he actually did these 4 elements, that we proved these 4 elements. And the state has proved those elements beyond a reasonable doubt. Moving on to count number 3 is the attempted assault in the 2nd degree against the person that he shot with the paintball. Once again, going through the elements again, occurred on August 15th. He intentionally attempted to cause physical injury to that person, firing at that range to a person with minimal head covering. He's not wearing the riot shield, the riot mask that Mr. Swinney was wearing. He's intending to cause him injury. He wants him to move away, so he said, and he's trying to cause injury to get that purpose, despite the fact that the man is standing there, filming him, not a threat. Moving on to count number 1, the attempted assault in the 4th degree. This is for the spraying of mace in this person's face here. Again, the act occurred on August 15th, and that he intentionally attempted to cause physical injury to another person. He told you he knows what mace can do, that it causes the pain, the discomfort, the impairment. That's why he brought it, to impair people for a significant amount of time. And that's what he did when he fired that mace into that person's face while they were not a threat, not armed, not masked, or goggled. That's an intent to cause that person pain, and very likely did cause that person quite a bit of pain. Count number 12, this is an assault in the 4th degree. This is for the use of bear mace against Ms. Stewart. Again, the act occurred on August 22nd, and he intentionally, knowingly, or recklessly caused physical injury to Ms. Stewart. I would argue to you that he intentionally caused that physical injury to her. She described him pointing the mace directly at her, pulling the trigger, spraying her face full of bear mace, and pain that caused for an extended period of time. That's an intentional act. But even if you didn't believe it was intentional, even if it was recklessly, substantially disregarding the risk that he would be injured by that, that would be enough. And clearly, spraying groups of people and then including Ms. Stewart would be a reckless act at the very least. Unlawful use of a mace, there are 2 charges of this, count 11. This is the same act that I just described as the assault in the 4th degree. It also constitutes an unlawful use of mace in the 2nd degree. And for this, we have to prove, again, just that he recklessly discharged the mace or a similar agent against her. That is clear. And again, self-defense is not an issue as to her. There is no argument that she was doing anything to threaten him, to make it necessary that he spray her full of mace. The second charge of unlawful use of a mace is count number 2. Again, the same elements, and this is for spraying the face of the person that was standing there, unarmed, unarmored, unprotected. Occurred on August 15th, and he recklessly discharged that mace against another person. Unlawful use of a weapon. Now, for these 3 charges, there's a slightly different theory here. The charge is slightly different than what you've heard on the other charges. Rather than a very specific moment and a very specific act, what you're going to see is that unlawful use of a weapon, as it's charged in this case, involves the possession with the intent to use unlawfully against another person a dangerous instrument. So count number 4 is on August 15th, the first day, possessing with the intent to use unlawfully the paintball gun. So clearly, throughout that day, he was possessing that paintball gun. Clearly, it was a dangerous weapon, as it was used that day as a dangerous weapon. And just as clearly, his intent that day was to use it unlawfully. Now, he would have you believe that it was purely a method of self-defense, but he was armed to the teeth with defensive and non-defensive weapons. He had armor, helmet, arm guard, padding, whatever that was. Those are purely defensive items, but clearly that wasn't enough for him, so he brought the paintball gun with the intent, as he stated in his social media posts, to fight, to bring his crusade, to literally fight the left. Bring that right's answer of violence to the left's violence. And so throughout that procession, certainly, where they're walking from the Justice Center to the parking garage, Mr. Swinney is possessing that paintball gun. He is intending to use it, and he did use it. Repeatedly. Firing it at the man in the belly, standing there doing nothing to threaten him. Firing it at the man with the phone. Firing it at Mr. Britton. Those are all instances that show his intent throughout that day to use that paintball gun at any opportunity to inflict pain. And again, it was not self-defense. Count number 7, this is for the act on August 22nd. Again, for that period of time where he is holding that paintball gun, possessing that paintball gun, and again, clearly with the intent that he is going to use it, he's going to use it to cause pain, he's going to use it unlawfully. And so throughout that day, and certainly in the instances where he's using it against Ms. Stewart, some of the other unarmored protesters, he's using it unlawfully, and he's possessing it with the intent to do so. Count number 8 is the unlawful use of a weapon. This involves the firearm. Now, an important fact to note here is in the definitions that you heard, use includes not just pulling it out and firing it at or near somebody. Use includes threatening immediate harm or injury. And that is clearly what Mr. Swinney was attempting to do with that gun that day. And again, in particular, when he pulls it out, aims it at unarmed protesters to threaten them of harm or injury. That's why he brought it there. To show these people that there are repercussions. Without the police, they have to face we the people. He brought ammo, he loaded it, and rather than seek cover, he used it. He used it to threaten. Clear as day. Count 9 for menacing. This is in particular the moment when he pulled out that firearm, pointed it at the group, including Ms. Carell, who told you that she was placed in fear of imminent serious physical injury, very likely fear of death, given that a loaded firearm was being pointed at her. And again, it's clear that by his own conduct, that was his intent when he pointed that firearm at Ms. Carell and everybody standing next to her. And then lastly, count 10, pointing a firearm at another. This is that same conduct on the 22nd, pointing and aiming, loaded or empty. In this case, it was loaded by his own admission toward another person, clearly within the range. Ms. Carell said it was maybe 20 feet away. So going through just the simple acts, you can see that the state has proved those elements beyond a reasonable doubt. In this case, we're also discussing, however, the defense of self-defense. I want to key in on a couple of particular phrases of particular importance. And those are that in order to be justified in using self-defense, he has to reasonably believe that the use of imminent force is necessary. Reasonable belief, and that the use of force is necessary because of an imminent threat. On August 15th, the defendant's actions were not reasonable, they were not necessary. The crowd that was following him, for the majority of it, the testimony was they were unarmed. Very few people even with gas masks, mostly casual clothing, following, and yes, shouting, but not making threats, not throwing punches, not threatening with weapons, and not coming at them in a threatening manner. In contrast to them, to the group following Mr. Swinney and his group was armed to the teeth. You can and should consider that in looking at what actions, what level of force is reasonably necessary, that a reasonable person in Mr. Swinney's circumstances, knowing what Mr. Swinney knew, a reasonable person would look at the group around them and the group following them and say, we're in pretty good shape because we all have gear.
Judge, I am going to have to object to this line of argument. The paramount issue is Mr. Swinney's experience, not the people around him.
I think it goes to the defense of others' defense, so I'll overrule that. You may continue.
Thank you. It is not reasonable to be standing in a group of people armed and armored with greater force to be used against the opposing group to feel that somebody walking towards you with no weapon, with a sign that says Black Lives Matter, that for some reason you need to use force against that person. That is not reasonable. We also know it's not reasonable because we heard Mr. Swinney describe what was really in his mind about the people that he assaulted that day. He was describing them not as threats, not as violent members of a mob. He described them as a nuisance, as agitators. When specifically asked about the difference, he told you no. Agitator, not necessarily somebody who's a threat. He saw these people that he shot with mace and paintballs as a nuisance. People who were talking too much, getting too close, but not threats. And you do not have a right, you are not justified in using force against somebody who is a nuisance or an agitator. The law only allows that when the use of force is reasonable and necessary because of an imminent threat. And on the 15th, his actions were not reasonable, they were not necessary. Similarly, with Mr. Britton, again, certainly he was yelling, calling names, calling him by name, calling him out particularly. But being loud, even being potentially obnoxious, is not a justification for using force against him. It's not a threat. And remember, Mr. Britton is justified in being upset, is justified in being loud and yelling and calling him names because what had happened right before Mr. Britton was shot, he had seen Mr. Swinney shooting and macing people who were unarmed. So he was justified in being upset, in yelling, in telling him to get out of here, get out of Portland. I want to spend just a few moments looking in particular at the video, some of the video, and indeed you should look at all of the video of the assault against Mr. Britton, but I want to take just a moment to describe why Mr. Britton was not a threat to him and why the man standing directly behind Mr. Britton was not a threat to him. One of the state's exhibits in which you can see, this is immediately before Mr. Britton comes into the frame, and you can see the young black man behind him walking up. Mr. Britton walking casually, not armed. He has a camera, a bag, a bandana, and flip-flops. You can also see, just in this frame, right behind him, a young man who is also walking, unarmed, not charging him. We can watch. He walks up, and Mr. Swinney points the gun, paintball gun. The man goes to block it. Shot. Is shot. And only after being struck by paintballs begins to advance forward. It was not reasonable for Mr. Swinney to see that man walking behind Mr. Britton and reasonably believe that he was a threat, that he was an imminent threat to Mr. Swinney or anybody in his group. What reasonable conclusion can you draw from a guy wearing gloves, casual clothing, tank top, walking up behind him? What reason could he be a threat? He was not a threat. And because neither Mr. Britton nor that young man were threats to Mr. Swinney, he was not justified in using the force that he did. The judge also told you that, and then on the 22nd, we also see that his actions, his use of force, was not reasonable. Firstly, it was not reasonable because the violence was exactly what he came there for. That was his plan. That was what he was looking for the whole time. Come and fight. This is our last stand. It is not reasonable to walk into a situation like that, intending to engage in violence, and then to engage in violence at the first opportunity. That is not reasonable, and it's not necessary. He fired round after round into the crowd, hitting Ms. Stewart, and undoubtedly hitting many others. And again, with regards to Ms. Stewart, there is no self-defense. The judge also told you there are exceptions to self-defense, the first of which is the initial aggressor. So when you look to August 15th, you can see that Mr. Swinney was not justified in using self-defense because he was the initial aggressor. We watched him strike the man in the vest, the reflective vest, without cause, without purpose, without need. He was the first aggressor. Continued walking, shot the man in the belly with the paintball gun. Again, the first and only aggressor at that point of the day. Nobody had responded, nobody had threatened him, nobody had brought out a weapon. And again, he continued as the first aggressor. He aggressed again, amping up the violence, escalating the violence, spraying mace in this person's face, shooting this man with the paintball. At every step of the way, he is escalating, he is the first aggressor, and nobody, certainly none of the people that he sprayed and shot that day, were threatening him or were following him in a threatening manner. Additionally, a person is not justified in using physical force on another if the force involved was the product of a combat by mutual agreement, not specifically authorized by law. Well, that's exactly what he wanted. Combat by mutual agreement. He made the call for people to come and fight, to make a stand, to hold them, to engage in a battle like he sees in the movies. And that's what he got. He called out for people to come and fight in Chapman Square and in front of the Justice Center, and that is exactly what happened. He called for his crowd to bring firearms. He knew there would be opposition. He knew the kind of activity that would happen when he got there and when he began using paintball guns and mace and tear gas on that crowd. And he got what he came for. The last thing I want you to keep in your mind as you're deliberating on this case is that the defendant planned for this day, for this trial, for this moment. He told you that he was hoping, he was planning for assaults, or something he could call assaults, to occur against him or his group. Somebody grabbing at his flag, somebody touching him, somebody getting too close. He wanted his group to take their own cameras and film it for this exact day, for this exact purpose, so that he could come in here, show you some video of other people doing other things. Hey, look over there at those people doing bad things too. Hoping, planning that you would ignore his actions, his plan, and find him not guilty because, well, some other people were doing bad stuff too at other places and other times. That's what he wanted the whole time. He wanted to see those things. He planned for those things to happen. And when they happened, it was go time. He did everything in his power to bring as much pain and as much violence to that crowd, to those people, as he could. Going to the Justice Center, it's going to be more than a normal flag wave. Everyone needs to have their cameras rolling. If anyone gets an assault, yell, got one. When we hear 3 or 4 say got one, it's go time. Why do you do all of this?
And I'm proud of every time we kick Antifa's ass, too, because they're enemies of this country. They're enemies of the Constitution, and they're domestic terrorists. And I don't care what anybody thinks about that. I don't care what anybody thinks about that. I hate them. I hate them. And I'm going to do everything I can to bring them down every chance I get. So I don't care what anybody thinks about that. It doesn't matter to me. It doesn't matter to me. And of course the left's going to hate that.
He came here because of his hatred for Antifa, his hatred for the left, whatever that means to him. He came here to enact a plan of violence. That's exactly what he did. And for those actions, I'm asking you to find him guilty on each and every count that is charged in this case. Thank you.
All right, members of the jury, we're going to break early for lunch today. We're going to take an hour for lunch. So I'd like you back in the jury rooms by 12:30. I'd like you to leave the instructions that we printed out for you in the courtroom because we are printing out new copies with the appropriate instructions all in order. At 12:30, we will come back. Mr. Westover will begin his closing argument, and then the state will have rebuttal, and then you will begin your deliberation. All rise for the jury.
Okay, so yeah, that's where we're at now. States made their case. defense gets to after lunch. State gets to argue why the defense is wrong, and maybe we'll get to a verdict today if if they can do deliberation in an hour. I don't know how realistic that is. I also don't know yet how we're going to know if when the verdict will be read. So I still have to figure that part out. But yeah, go ahead, and I'm gonna shut down the stream here in just a minute. I will see you back after lunch. Take care.